So as part of my role in planning the CLE, I tend to speak and present. So I'm covering Iowa case law developments, focusing on the Court of Appeals and Iowa Supreme Court decisions over the last year. So I know Gary talked about this case a little bit in his presentation, but I wanted to discuss it in a little more depth and maybe also comment on some of the differences between the overdraft issues here and the case in the agri-processors case that he referenced. So as he said, this involved a class action on behalf of a bunch of bank customers who were challenging the NSF fees that were charged when the customers would create overdrafts in their account. So as far as the process of the transactions, most of you are probably familiar, but at the point of sale, the decision of whether to deny or allow the transaction is made then. And the posting actually happens 1 to 3 days later, so it actually hits the account sometime after that point. And if the transaction is allowed, the bank is required to pay that transaction, even if sometime in that 1 to 3 day period, the account doesn't have sufficient funds to cover it. And so also, as Gary said, these transactions are posted in a batch, usually at the end of the day. And here, the bank used to process the transactions from low to high, changed from high to low. So that created in more overdrafts for the customers because, say you have $100 in your bank account and you have 3 transactions hitting that day. One is for $100, the other 2 are for $10 each. If you went low to high, you'd only get that 1 fee because you get hit with each transaction, generally. Now, the bank always had discretion to reverse those fees and sometimes did in this case, but not always. So the petition had a variety of different types of claims. So first of all, they claimed usury under the Iowa Consumer Credit Code because the NSF fees amounted to a finance charge in excess of 21% in violation of Section 537-2201. Kind of an interesting point, during the pendency of this case, the Iowa legislature actually acted and specifically took out of the definition of finance charge these NSF fees. So that kind of became a moot issue, but that was at least raised in the petition. The other category of claims was regarding the sequencing. And there was unjust enrichment claimed, and there was also the implied and express duties of good faith that Gary referred to. So at the district court level, the bank lost, got a partial grant of summary judgment, but lost on the usury and sequencing claims. So the bank moved for interlocutory appeal, also on the class action certification and on the denial of their motion for summary judgment, which is kind of rare. Usually you don't see an appeal on the denial of a summary judgment because that often doesn't work. So the bank's theory was that the overdraft was not an extension of credit under the definition of the ICCC, and also that the NSF fees weren't actually finance charges. So the court agreed with the bank and found that the overdraft was not an extension of credit. So under the Iowa Consumer Credit Code, there are 2 relevant questions in determining whether there has been an extension of credit. So 1, is there the ability to defer payment on the part of the customer? And 2, when was the money actually due and payable to the bank? So here the court found that there wasn't any right to defer payment that was a part of the deposit agreement. The bank had the immediate right to collect payment as soon as there were sufficient funds hitting that account, and so money was due and payable right at the time of the overdraft. So the court distinguished some of the other types of cases where an overdraft has been found to be an extension of credit, including that agri-processors case. So Gary was referring to one part of that case as far as the intraday overdrafts. So intraday overdrafts are typically when account goes negative, but the customer is able to fix it before the midnight deadline, which is on the next day. And even though it's technically an overnight overdraft, the court refers to it as an intraday overdraft, which is a little confusing. Now, in agriprocessors, there were actually overnight overdrafts that extended for a period of months. And so there was, in that case, found to be an antecedent debt and a preference. And the bank was, I think, liable for about $1.5 million. That was appealed, so that was the bankruptcy court decision. Then Judge Reed issued the Northern District of Iowa decision affirming, and now it's on appeal again to the 8th Circuit. So we'll see how they treat that. But as far as in Legg v. West Bank, the Iowa Consumer Credit Code has a much narrower definition of credit. In the bankruptcy code, it's very broad. Debts, these terms are defined in each of these statutes, and they're defined very differently. So as far as the different types of sequencing claims, first there was a theory under unjust enrichment. And the court didn't really go into this too much, but unjust enrichment is that sort of quasi-contract theory. It's kind of a restitution form. And when you're looking at the difference between express and implied contracts, the courts have held that you can't have express and implied contracts on the same subject matter. So in this case, the court found that the deposit agreement expressly addressed the NSF fee issue, and so they found that, actually I say properly dismissed, but that actually the court should have granted summary judgment on that issue, and so that was improper of the district court. Now, as far as the good faith claims, the plaintiffs claimed that there were implied and express duties of good faith. Now, again, because you can't have implied and express contracts, the court found here that the one that applied was the express duty, because the deposit agreement actually had these provisions of the bank owing this duty of good faith with respect to each account. And in this case, there was some evidence that the bank had consulted with a compliance officer, concluded in an internal memo that they should notify their customers, but then they didn't. So the court found that there was enough of a fact issue that the bank didn't adhere to that duty of good faith that was expressed in the agreement. And also they addressed which statute of limitations applied. Because it was a written contract, it was the 10-year statute of limitations. And also, anyone should feel free to chime in. I'm not going to be bothered if you interrupt me to ask any questions or talk about any of these a little further. So Legg v. West Bank actually had two decisions. So the first one was the merits, and the second one was on the class action issue. So the court found that the district court, or the Iowa Supreme Court, found that class action on those good faith claims was appropriate. So the requirements are in Iowa Rule of Civil Procedure 1.261, basically numerosity and commonality. The parties stipulated that there were so many bank customers that that element was met. As far as commonality, which is where a lot of these disputes really center, the bank argued that there are going to be a lot of individual issues because the amount of the overdraft varied. When fees were reversed varied. And so they tried to make that argument here, but appellate courts are generally pretty deferential to district courts on this issue, so they allowed that to proceed. The other requirements, of course, are that the class will promote the fair and efficient adjudication, and that the representatives that are there fairly and adequately protect the interests of the class. There are a lot of factors, and it's kind of a flexible sort of standard, and that was able to proceed. So the next couple of cases are about EDMS and some of the changes that were brought about by this drastic overhaul of our filing system. So this case involved concerned citizens seeking judicial review of a board decision regarding annexation of land that was near a high school. So District Court affirms the board decision with an electronically filed ruling on 7/11/14. Filing stamp says e-filed July 11th. Now on 7/15/14, the actual notice of electronic filing went through. And so that's when all of the parties get notice that this decision has been entered. And if anybody here has e-filed anything, you know there are 3 emails. So first it's received, then it's accepted, and then you get the notice of electronic filing. Sometimes, and this was more of a problem I think when it first came out, but there could be a significant lag time between the time you submit it for filing and the time that you actually get that notice that's file stamped. And that's what really shows that it's filed. So here, again, there was a several-day delay. The official file stamp on that notice said 7/11/14. Parties didn't get it until later. Now, on August 12th, a notice of appeal was filed in the case. Also, a motion for extension was raised. The board subsequently filed a motion to dismiss as the appeal was untimely. They resisted the motion for extension. The court denied the motion and ordered briefing on the motion to dismiss. So here are a lot of excerpts from that decision and from the actual Chapter 16 rules. So the court here really kind of takes this apart, goes over this language pretty carefully. So filing is defined under the EDMS rules. It's the electronic transmission of a document together with the production and transmission of the notice of electronic filing. So that's expressly referenced there. Once it's submitted, the notice is generated. Electronic documents are not officially filed without the electronic filing stamp. And the date and time that's recorded is the official filing date and time of the document, regardless of when the filer actually transmitted it. That is language from the rules. Another excerpt is that the filing has the same force and effect as a filing that was submitted in a non-electronic manner, so prior to the adoption of EDMS. It only receives that same force and effect once it receives the stamp.
Would you repeat that one more time, that filing case, please?
Sorry.
Electronic filing has the same force and effect as filing and stamp non-electronic.
So all of this language taken together really suggests that it isn't filed until you get that notice and until you get that stamp. It's that date on the stamp. Yes.
That's a good question. I want to see what you think, though. What if you don't get the email?
That's exactly what happened in this case because of that lag time. So because, and this hasn't really...
What if you don't get it at all?
Oh, well, that kind of brings me to the next issue. So if you file a motion for extension, in a notice of appeal context, you can only get the extension if the court hasn't notified you. And so this is kind of a particularly harsh rule when you're talking about notice of appeal and that timeline. Now, in a lot of contexts, if you somehow don't get the email, well, first of all, sometimes it's your fault. I had an issue where I didn't realize that I had my own appellate EDMS that was set up, so those are separate, and I didn't get any notice, or I wasn't getting the emails that were going to that account. And that was my problem. I only had my regular EDMS set up, and so I was only getting those emails. But what happened was when that appellate EDMS system was launched, you were automatically signed up using whatever email address you had at the time. I had a different email address at the time. And nobody told me, hey, you're getting an appellate EDMS. So I didn't know that. So I called the clerk and she said, oh, well, you have to change it. This is the process for it. But, I mean, a lot of this is kind of your responsibility. You just have to figure this stuff out. And if you have appeared in a case and you're not getting any emails, it's your obligation to ask questions is kind of what I've been hearing. Now, in a lot of contexts, the courts are probably going to be more forgiving, though. Say you miss resistance to a motion by a few days or something. The court's probably not going to strike that. But when you have a notice of appeal context, it's jurisdictional and mandatory. So if you don't get it in within 30 days, then you lose your right to appeal. And so here the court was saying that even though the parties didn't get notice of that ruling until July 15th, the filing date was July 11th. It was backdated. And that was the date that starts the clock running for your appeal. And so here, the party was only 1 day late, but that was enough to take out jurisdiction, and the court dismissed it. There was a dissent from Mansfield and Waterman saying that they thought that you should go with the date that everybody gets the notice. I mean, because that effectively reduces your time to respond to the appeal. I've seen this also, a similar argument raised as far as the statute of limitations. So say that your statute starts running on January 1, 2015. So you have to file, say, 2 years. And say you submit your filing on January 1, 2017, but it's rejected by the clerk for some reason, or it doesn't go through for some reason. And then you have to resubmit it, or for whatever reason, you get a filing stamp of January 3rd. January 1 might not be a good example because of holiday, but you get the point. Is that time barred? Under these rules, the court, the majority said, well, the filing stamp is the date. And since the adoption of EDMS, I've been finding that the clerks are processing these a lot faster. And I know that within CMECF, for instance, I never had a problem. That was the thing I loved about CMECF initially, was that, boom, you file it, it comes through, you don't have to worry about that. You can see it, you can click on it immediately. With this, you don't know. You don't know when the clerk is going to process it through. So if you're up against a deadline, I mean, there are certain things you can do if you're, what you have to do is serve it, for instance. You can serve it by email. That's what I was doing if I was up against a deadline, is I would send an email with my document to whoever needed to get it, and then it could be served by EDMS later, but at least I'd served it, and under the rules, as long as you serve it timely and file it within a reasonable time thereafter, it doesn't matter. So, but for some things, like filing a petition, notice of appeal, this can be a really harsh result. I think in a lot of those other contexts, the courts are probably going to be more forgiving, but here they clearly weren't. And the same result was reached in this the second case, and it was almost the exact same facts, where 1 day late, and that was enough. So I think that a lot of people or a lot of clerks have adopted a system of just sending it through immediately. And I know that that's an issue with the Northern District of Iowa, for instance. So it's my understanding that the district court doesn't do that. They don't automatically let it fly through as soon as you click submit, that the clerk reviews it. Now in bankruptcy court, they send it right through, and it's my understanding that was a clerk just policy that maybe a former judge might have ordered down to make sure that those problems don't happen. I mean, because that's pretty harsh where somebody tries to file it and through no control of their own, it doesn't get filed. Do you have a question?
Yes, when we went to the electronic filing, we had a committee of a lot of the local lawyers. Wes was on some of those, but the question came up then about what happens if, because there's a whole dictionary of ways you can file up, and the question was whether they would be kicked out and sent back without filing, or whether they would be accepted. And Judge Edmonds and I finally decided, with a lot of input from the bar, that for all these reasons, it was unfair to let it hang and then send it back after 4 or 5 days and have it rejected. So our policy, and I think we put it into our local rules when we did it, was that we would accept all filings and then deal with it after the fact. Because that way, if there was a statute of limitations or a time bar, at least you knew that you had a time stamp that was going to allow it to proceed. And then when we added, or the feature in our system was that the attorneys can access the clerk's files through the computer, and that way they could always tell the time and the date when things were filed. It really eliminated that problem for us.
And so again, I think that some clerks in the state courts are also doing something similar, but I mean, if they don't, there's not a lot you can do, and this is some kind of scary precedent. So the next case is Ganson versus Ganson, and this involved a constitutional law question. So here, Francis Ganson created a trust, and the trust received 2 tracts of farmland. That trust entered into leases with James Ganson in 1997. The initial term was 5 years, and there were option to renew clauses of additional 5-year periods, and the option was solely the tenants as to whether to renew. The lease also called for annual reconsideration of the rental rate. And between 1997 and 2007, the rent was $120 per acre, and everything was going fine. The parties were agreeing on the rental rate every year. Then in 2007, a round of litigation starts. So the trustee files a declaratory action with 3 counts. So first, they were claiming that James refused to negotiate in good faith, and that was a breach of the lease. They thought that he was being unreasonable in his position on the rental rate. Second count asked that the court set a fair and reasonable rate, and the third count asked for the leases to be deemed terminated for failure to include a material term, which was the rent. So the district court here in round 1 found that there wasn't a breach but set a rate. Second round of litigation commenced in 2013 with another declaratory action. Again, 3 counts, but a little different this time. So first, that one stayed the same. James breached duty of good faith, and there was a request for the court to set a rate. But count 2 alleged that the leases violated the Iowa Constitution in creating a lease that could last more than 20 years, and that is prohibited by the Iowa State Constitution and the Constitution of about 5 other states. Count 3 stated that the lease is terminated pursuant to notices that were served by the trustee. James filed a counterclaim stating that counts 2 and 3 were barred by res judicata. District court granted partial summary judgment on the constitutional issue. So, requirements of res judicata. First, you have to have the same parties in the first and second actions, and the claim that's brought in the second suit could have been fully and fairly adjudicated in the first suit. Third, you need a final judgment on the merits. Now here, all 3 elements were met as far as these 2 counts that were raised in the second action. So none of the parties raised this issue, but the Iowa Supreme Court first considered whether res judicata, or claim preclusion, actually applies when the first action is a declaratory action. The court noted that there are some different states that have come out differently on that issue. Some have said that it shouldn't be barred, and some have said it still is. And the rationale, so here the Iowa Supreme Court said we're not going to apply res judicata in that context. And the reason is, well, there were a few reasons. But one, they looked at declaratory actions in general as being intended to supply a very fast remedy for parties, that sometimes these are brought before everybody really knows all of the disputes and all of the issues that might be raised. And to require joinder of other claims might complicate those actions, because if you want them to be more streamlined, faster, and allow for adjudication before things get really ugly, you want to encourage them to be kind of simple. There was kind of some artful language in here about the difference between a declaratory action and a real civil litigation suit is the difference between diplomacy and war. And I mean, I don't know about other declaratory action litigators, but I have found they are just as ugly and contentious as a general matter. But here the court holds that only issue preclusion will apply when the first action is a declaratory action. So, I mean, that was kind of a significant holding here, and one that I thought had broader implications kind of beyond the constitutional issue. But addressing that, the court did find that because only the tenant could opt out, one of the parties may be locked into a lease lasting longer than 20 years, and so the lease would be invalid after 20 years. And here, since it commenced in 1997, it's going to be invalid 20 years from that date. They noted the history of that constitutional provision, and generally it was intended to protect tenants rather than landlords, but they said the language doesn't run solely in favor of tenants, so they applied that ruling here. And they also noted that there's nothing to stop the parties from renewing the lease or signing a subsequent contract. It was just, if that's the contract that could be or could extend beyond 20 years, then that's when we're going to invalidate that agreement. Lubbers versus MDM Polk is a parole evidence rule case. And background here, MDM entered into a real estate purchase agreement with Lubbers. They wanted to build a hog confinement facility. There was an integration clause in that contract, and there was also a clause in the contract that referred to a manure easement agreement. And the parties had an oral agreement that Lubbers was going to receive all of the manure that was produced at that facility at no cost. MDM eventually dissolves, sells its property to a third party, and in that agreement there's a provision that says, look, for the extension or for the rest of 2012, give Lubbers the manure. And then in 2013 they stop giving Lubbers the manure. So Lubbers files an action against MDM. They claim that MDM breached the agreement and the oral contract and made a fraudulent misrepresentation to the extent of, look, we're going to give you the manure, and then they didn't make sure that that was going to go forward. So the district court granted the motion for summary judgment that was filed by MDM, finding that this was a fully integrated contract. I mean, if you have that integration clause, that's generally a good sign. Now, it's not the only sign, and the courts have said that sometimes they'll look to other things, but here the district court found that's enough, and we're not going to allow any evidence regarding this oral agreement or anything else. This is the contract. So the Lubbers Trust appealed, alleging that they should be allowed to introduce some evidence about this contract, because the real estate purchase agreement wasn't intended to be the complete expression of the agreement. So here the court held that there was ambiguity in the agreement, and so that's really what you have to argue if you're trying to introduce other evidence, is that there's some ambiguity. And here, I mean, it seemed pretty minimal what the ambiguity was, but there was some language referencing this manure easement, and so the court found that summary judgment ruling should be reversed. There was also a claim that in the written contract, there was just this one recital that the buyer and the seller desired to enter into this separate agreement, and there was a reference to there being another separate agreement. But the court found that, look, that clause itself is simply an agreement to agree, and that's not enough to establish there's a manure easement. You need that separate contract. There also wasn't really enough to support fraudulent misrepresentation, pretty high standards, so that's how that case came out. There are a couple of Iowa Court of Appeals decisions that came out in late 2015 about piercing the corporate veil that were really seeming to extend personal liability for LLC shareholders. So this first case involved Minger Construction, who contracts with City to upgrade sewer system. Minger enters into an agreement with Clark Farms to remove sludge. So Clark Farms has Kevin Clark as the sole owner, shareholder, board member, and president. So a fact that comes into play later is that corporation was incorporated in 2001, administratively dissolved in 2012 at the time of the contract with Minger, and corporate status was reinstated in 2013. Clark Farms eventually ran into problems fulfilling the contract, including equipment failure and a whole host of issues that are detailed in the decision. So Minger eventually terminates the contract, gets someone else to do it, and sues Clark Farms for breach and seeks to impose personal liability on Kevin Clark. So a jury found Kevin Clark breached the contract, or Clark Farms breached the contract. Kevin Clark should be held personally liable. So he appeals. Majority affirms shareholder liability in this case. So there's a lot of discussion about the jury instructions and the different factors that are set forth in determining whether to pierce the corporate veil. Specifically, whether an abuse of the corporate privilege was established. So some of those factors are, was the LLC or corporation undercapitalized? Were there separate books? Were corporate formalities followed? So here the Court of Appeals found that a reasonable juror could have found those factors were met when Kevin Clark allowed the registration to lapse. He made $530,000 in loans to the company and personally lost over $800,000 over the life of the company. There was a very lengthy and well-written dissent by Judge McDonald in this case, partial dissent on just the personal liability issue. So he first argues that this shouldn't be a jury question at all. It should be a question for the court. He notes that there isn't really a lot of guidance to jurors in how to reconcile these factors, how many are necessary to be met, and it's kind of a complicated issue. He points to some other types of cases where corporate governance issues are considered questions for the court. And also that this is an equitable remedy, and so that kind of makes it more within the province of the courts to decide. And that these cases, this is such a litigated issue, but a lot of the cases don't really give you a lot of very helpful guidance themselves. He speaks of these generalities, near shell, sham, alter ego, but there's not a lot of explanation of what that really means. And here, I think I'm going the wrong way. So here you have a person who's sending money into the corporation, but you don't really see it coming back. There's no evidence of that. And he just thinks that this seems pretty harsh under these facts. And this wasn't subsequently appealed. This case stood. I was kind of curious to see whether there might be further appeal. But kind of similar issues in this Keith Smith Company versus Bushman case. So this was relating to an egg hatching corporate structure. So the Bushmans, married couple, were 50% owners of this corporate entity that was created to purchase eggs for hatching. and then coordinate delivery, and then process. And so there were several Bushman-related entities along the way, and CPP, the one that would process, was related partly. There were some other players as well. And so this entity contracts with this out-of-state corporation, this Keith Smith company, to supply the eggs. Before signing the agreement, KSC demands financial information, reviews it, they come and inspect the barns, so they do their due diligence. Over about 5 months, KSC ships a lot of eggs to FGP and isn't paid initially, receives a lot of payment, receives about $500,000 in payments, but in the end, things go badly for the business and they're owed about $250,000. So KSC sues for breach of contract over these unpaid invoices and asks that the Bushmans and all of their related entities are personally liable for the debt. So this was a bench trial. So this didn't go to the jury, but after a bench trial, the court found that there was enough to impose personal liability on the Bushmans. So the Court of Appeals affirmed that decision, noting a few specific facts of the case. So one, the agreement was actually signed 1 month before this entity was formally formed, and so that kind of suggested maybe they weren't following corporate formalities. Next, there wasn't a line of credit. FGP had no employees. It moved funds between other related entities and wasn't adequately capitalized to fund these egg purchases. So right from the beginning, they knew there was going to be like a 10-week lag or something before they could begin making payments. So they were reasoning that this business is carrying on without enough assets. It's not really fair that these creditors are left holding the bag. Now, they also note that best practices would involve a personal guarantee of some sort. I mean, that's one of the ways that you can kind of guarantee the personal liability. But here they thought, look, this company didn't really have any reason to think that they weren't adequately funded. Now, they find that there is enough. Again, it's kind of a deferential standard of review. But they didn't impose liability on all of the related entities, just the Bushmans, because the other related entities weren't really part of any of these deals, didn't contract with them, and so that's where it stopped. But Judge McDonald, again, wrote a pretty lengthy dissent on this personal liability issue. So he found, first of all, in the context of a contractual dispute, generally there are more stringent standards. This was a sophisticated entity, too, that was dealing with the Bushmans. And, you know, they're kind of presumed to voluntarily and knowingly enter into this contract. And he noted that they had the ability and opportunity to review their information, and nothing showed any substantial assets of FGP. So they didn't really have any reason to think that there was that was funded, because there wasn't evidence of it. And also, they could have gotten a personal guarantee, and they didn't. So again, I think there's really good language in the dissent to point to if this issue comes up, but I thought that it seemed kind of broad, because again, you know, this is something that really is only supposed to be applied in exceptional circumstances. He didn't think that there were exceptional circumstances here, because this was an entity that, I mean, it had a legitimate business goal, a specific plan. There was knowledge that it was a startup, it was brand new, and they kept separate finances. And here again, there wasn't any evidence that FGP was paying personal obligations of the Bushmans, and that's really what you're more concerned about, is money flowing the other way. You know, are they using this entity as their own personal piggy bank? And there wasn't any evidence of that here. And these are people that are doing the opposite. They're funneling money in to try and keep it going. So, a couple of interesting cases there. There is a pair of cases addressing mortgage foreclosures and the statute of limitations. So in U.S. Bank v. Lamb, Lamb and Callan defaulted on their mortgage loan. The bank obtained a decree of foreclosure in February of 2010. There were 2 sheriff sales that were scheduled and subsequently canceled by the bank. The bank eventually filed a notice of rescission in March of 2012, which was more than 2 years after the entry of the judgment. And so the bank then filed the current foreclosure action, seeking foreclosure in October of 2013 and a motion for summary judgment. District Court granted, and Lamb and Callan appealed. Court of Appeals affirmed. Is that the same one? Okay. So Lamb and Callan's argument was that the statute of limitations required that the bank enforce its March 2012 judgment within 2 years, and they didn't do that, so that extinguished all liens and all interests, including any interest in the underlying property. They also argued that rescission itself was barred after 2 years. So the bank would then be left with in personam remedies, but not any in rem remedies. So the bank argued that only the judgment lien was extinguished and that the rescission was proper. The Iowa Supreme Court agreed with the bank. So first, they did kind of interestingly find that the all liens language in Chapter 615 was sufficiently ambiguous to require interpretation, because you're going to apply that plain meaning rule pretty cautiously, they said. And so they look at the context. It's in the chapter that's called Limitations on Judgments, in a section referring to judgments, and so that context really suggested they're just referring to the judgment lien. And the legislature could have made a different intent a lot clearer and less ambiguous. They also found that the rescission is not barred after 2 years. So 654.17 permits rescission before mortgagee rights become unenforceable. So the court found that that means more than just the judgment lien. Also, they noted that the penalty for mortgagees who rescind judgments is just forfeiture of the right to obtain a deficiency judgment in a later action. So that kind of suggests like that's the only penalty that's imposed. It's not an extinguishing the mortgage and all underlying interests. So Kobal v. Wells Fargo addressed the same issues, but also included a different issue on appeal, which was that there Kobal asserted an unclean hands defense to the foreclosure action. So the court first raised the question as to whether that was even properly presented to the district court, but they found that the court didn't rule on it, and since Kobal didn't file a motion to enlarge under 1.904, that issue was waived. And so that raises kind of an interesting issue for a lot of litigants who are trying to decide whether to file that 1.904 motion. There have been a few cases in recent years that suggest you better err on the side of caution and file it if you think that's going to be an appeal point later, because if it's raised and the court doesn't address it, then you can lose it. So the next case is one that our firm was involved in, actually. Linda Kirsch here today was key in this one. So here, the bank loaned millions of dollars to this entity that was a nonprofit that provided residential health care services to Eastern Iowans with physical, mental, and intellectual disabilities. So they made sure that their loans were secured and all interests were properly perfected. Eventually, the state investigates CCI regarding some alleged Medicaid overpayments, and they eventually request appointment of a receiver And DeWitt was, I think, aware that there was a receiver being appointed, but they didn't really comment on it. There wasn't any objection or opposition to the appointment. And the district court entered an order appointing the receiver and setting compensation and ordering through pretty specific language that the receiver would receive super priority payments. So that phrase kind of caught the attention of DeWitt Bank. They filed a motion to intervene and argued that the receiver didn't have any right to avoid their liens to cover the costs of the receivership. So the district court ruled against DeWitt Bank, finding that Section 680.7 allows a receiver to avoid liens in favor of a receivership. And the secured creditor is just kind of out of luck. So DeWitt filed a motion for interlocutory appeal. And there, the Iowa Supreme Court first kind of recognized this general rule that administrative expenses of a receiver are generally paid from unencumbered assets. So don't go looking to secured assets if there's not really a reason to. A secured creditor is really liable only for reasonable and necessary expenses of preserving or disposing of the collateral to the extent of a benefit that's received by that creditor. So if there isn't a showing of a benefit to DeWitt Bank, and DeWitt Bank was arguing there wasn't, they couldn't have their collateral compromised. So the court rejected the argument also that DeWitt Bank actually consented to the receivership. They found that as soon as they understood that their interests were being threatened, they promptly moved, they filed their motion, and so that wasn't a reasonable argument. The matter was remanded to ascertain the extent of any benefit that was conferred, and I'm not actually sure the status of that. Linda? Oh, it was settled. So kind of clarifying some of the receivership law. So that's, I think, the presentation. Does anyone have any questions about any of the cases or any of the issues that are raised by those cases? No?